Good morning for all those who are here already on Facebook Live. This is the first time we've ever done a Facebook Live event. So if there's some sort of things that we do incorrectly or an error that you feel, let me know in your comments. We're going to give a couple minutes to see if there are, because I know some people will be arriving later to this event. But I know that others have asked questions already, and we'll go over those things in just a second. This Facebook Live event is going to last for approximately 1 hour. We will record this so that if there are other people had questions at another time or want to see it, then that'll be available. We also have, for those who are not available today or won't be able to stay for any link today, we do have workshops every 3 weeks. If you're interested in attending one of those workshops, all you have to do is call our telephone number at 214-720-0102. That's 214-720-0102, or sign up online at our website, dallaselderlawyer.com. That's dallaselderlawyer.com. Well, without further ado, I think I'm going to answer some of the questions that have been submitted previously, and certainly if you have comments on this thing, I'm going to try to address the comments that I see as we go forward. I see the first question is from Andrew. It looks like in the Dallas area. I'm wondering the pros and cons of a ladybird deed versus a transfer on death deed. And his mom was considering a ladybird deed. Well, I think I first need to explain to those who don't know what a ladybird deed is or a transfer on death deed before I can tell you what the differences are. A ladybird deed is, first of all, ladybird has nothing to do with Lady Bird Johnson. It was actually an attorney in Florida was giving an example of and using different names, and he thought the name ladybird would be a good way to explain this type of deed. The name caught on, and that's been probably 15 to 20 years ago, and it stuck. It's kind of like saying Hoover for a vacuum or something like that. People just seem to call it these things, even though it's really what's called an enhanced life estate deed. An enhanced life estate deed is well, first of all, what's a life estate deed? I have my home. I have the right to live in my home for my life, and then upon my death, it goes to so-and-so. That is a life estate deed. Now, for Medicaid purposes, why Medicaid? Because Medicaid helps pay for many people's long-term care, whether it be at home or sometimes assisted living, or not only at home, assisted living or nursing home care. But the government has a right to make a claim against that exempt resource, the homestead, after death to recuperate the benefits that they have paid out. Now, you could have a ladybird deed even if you weren't applying for public benefits. And so if the only asset that you had was your home and you wanted to avoid probate, you wanted to go a certain way, then a ladybird deed or a transfer on death deed could be utilized as a way to transfer property upon your passing. On either the ladybird deed or a transfer on death deed, it avoids probate. Okay, so probate means things that go by will or by intestacy for that matter too. You could have, it avoids things going by intestacy. So if you want something to go to a certain person only or to a trust, you can use that to your advantage, and it might be less expensive than maybe going to court to probate a will, and there's another reason, and the other reason is for Medicaid, if things go by probate. In other words, if you go to court to probate a will, then the state has a right to make a claim against that home to the extent that Medicaid benefits have been advanced. So the first thing is on a ladybird deed, this enhanced life estate deed, it said the difference between enhanced and a regular life estate deed. An enhanced life estate deed gives more powers. If I just had a regular life estate deed, a life estate deed that says upon my death it goes to my children, my home, then if that had been done within 5 years, then if you ever applied for like long-term care Medicaid or some of the other Medicaid programs, not all the Medicaid programs, there's 40 or 50 Medicaid programs in Texas, all with their own rules. But the idea is if you have a transfer and you just said, I give a life estate and that was it, then there would be, within 5 years, then the government would penalize you based upon, they would look at that person's age and they say, well, you've given up, because now these, let's say, children have a remainder interest in the property. And so they would look at the age and see how much has been transferred, because they think that you reduced your assets on purpose to get public benefits, because public benefits are means tested, even though a homestead doesn't count as a resource. So here, an enhanced life estate deed is one in which you retain all powers. If I were to sell the property, I, the one who set up the Ladybird deed, retain all the benefits, that is, all the assets. If I were to mortgage the property, I get the proceeds of that mortgage. If I were to lease that property, I get all the income. In fact, if I want to change my mind on who those beneficiaries might be, I could do so. I could do whatever I want. So under the Medicaid rules, since I could do with my property whatever I want, and it just goes to these people upon death, then it is not a transfer penalty because I'm still in control. And control is usually a key issue on anything, not only in Medicaid issues, but also like in tax issues as well. So the enhanced life estate, and in Texas, I should tell you, and not all states are like this. In Texas, the state has a right to go after the exempt resources generally, unless there is a beneficiary designation. So let's say you had a retirement account that was exempt. Not all retirement accounts are exempt, I might add. And you had a beneficiary listed, or if you had, in this case, a home has a beneficiary designation by having it go directly to that person after death. And that would be the case for a transfer on death deed too, and I'll mention that in just a second. It goes directly to whoever that beneficiary might be, and so it avoids estate recovery because it avoids probate too. Now, a Ladybird deed does give good title, not only how you got it, but going back, it's almost like from the way title companies look to say, going back from that person, the person before, etc., all the way from when we've had records here in Texas. However, a transfer on death deed is a deed that just a form, very simple form. The state legislature has provided that, and it just says who it goes to upon your death. And you might say, well, why not just do a transfer on death deed? Well, there are a few reasons why you wouldn't. First of all, that title wouldn't go back all the way through time. It would just go back to how you got it. The second reason why a transfer on death deed is used sometimes less is that you cannot use a power of attorney. A power of attorney is a document which gives somebody the authority to act on your behalf during your lifetime, a general durable power of attorney. Now, the power of attorney dictates what those powers are, but usually most general powers of attorney deal with real estate transactions. So, but a power of attorney cannot be utilized under law for a transfer on death deed, whereas a power of attorney can be used for a Ladybird deed. So in other words, if I had a parent who was disabled, then I could do a Ladybird deed for that parent. Now you would want to be consistent with with whatever that person's will or laws of intestacy if there was no will. In other words, if the will said, I want the house to go to this one child only, then the Ladybird deed should only go to that one child also. It should be consistent with the person's intent, the testator, the one who signs the will's intent. Otherwise, title companies may have a problem of issuing good title. So generally, if we do a ladybird deed, knowing because of what title companies may look at, we also might do a will to confirm that it is consistent with the ladybird deed as the last will. This could, a lot of times, ladybird deeds can be used in other ways too, that we want to, if we only want one person in control, then we could do that by having the deed go into a trust. So for example, let's say that there were 5 children and one of the children didn't get along with, we know that they're always going to have a problem. They won't agree to sell the property, or they won't agree to, or maybe the purchase price or whatever. You could do a ladybird deed where it goes into a trust, assuming the person who has capacity, the person who's doing the ladybird deed has capacity and can prepare a trust. Unless the power of attorney gives the ability to create a trust. That's one of those extra things you put in a power of attorney that are not usually allowed by the statute. In other words, the law says, doesn't give the authority in a general statutory power of attorney the ability to create a trust. So here you could create a power of attorney that does get that ability. Well, in any event, a lot of times the flexibility of the ladybird deed is you could do things in different ways. Let's say it's a husband-wife. It could be that, and you have children, it could be that you want half to go, if the first one to die, to the children, or it could be upon both of them dying. It's whatever way you want to design it. And it doesn't have to just be on a homestead. We're doing one right now where we had done an irrevocable trust to get the look-back period going for Medicaid. Medicaid, you can remember, I mentioned, has a 5-year look-back period. So we had put assets in a trust, but then we found out that the person who set up that trust, who wanted to transfer assets so they wouldn't count for Medicaid if it was needed at a later date, inherited some mineral rights. Well, mineral rights are also, it's depending upon how much the value is. They could be an exempt resource if they're relatively nominal in value. So we want to be able to have a power of attorney that can give us some authority to do those things, and you could do a ladybird deed on mineral rights as well. I see that there's a couple other questions, and I'm going to get to the questions of Gary's in just a second about the power of attorney and probate. Why do you want to avoid probate was Gary's question. And the answer to that is that, well, a lot of time, well, there's several reasons. Well, first of all, avoiding courts. We don't want to have to, a lot of times probate can be simple in Texas, but sometimes it's difficult, and different judges, quite frankly, have their own rules. And so a lot of times people want to avoid those courts. The other reason is sometimes there's will contests. Even if the things go equally to the children, we've seen situations where one child says that's not good enough. The other situations could be you have to go by the state's laws. So in other words, you not only file an application for probate, you have to give notice to all the beneficiaries. You might have to do an inventory. So maybe you want to avoid not only the courts, but you might want privacy. Nowadays, it seems like people try to get as much information about others as humanly possible to use that in some sinister way. So with a trust, it's not filed, and you don't have to wait. Remember, for probate, there's a waiting period after you file the application for probate. So this gives somebody not only the opportunity to contest, but it means also things may not be resolved quicker. With probate, not only with a trust, you not only avoid probate, you have privacy. You may not have to, you're not going to do an inventory. It's less likely that there'll be a lawsuit, because with a will, gives more time to contest who's the guardian, the executor, etc. And so you have to, give notice to creditors, etc., etc. There are certain rules that you have to follow through probate. And there's also likely, there could be mistakes. Yesterday, I got a call from somebody, they couldn't find mom's will. The will was a good will. There wasn't a problem with it. The will had been done in 2011, but they only had a copy of the will. You have to keep the original in a safe place. Otherwise, the court presumes it's been destroyed. And then you have to maybe bring witnesses, and maybe this will was an old will. And so that creates a problem too. Or maybe somebody, the notary, didn't sign in a certain spot, or maybe the witnesses failed to sign a spot. So now you have all the different rules that are required under the estates code here in Texas. And of course, I'm only talking about Texas law. By the way, ladybird deeds are not in every state. We're in the minority states. There's only about 10 states that have ladybird deeds. So you would, a lot of times you want to avoid probate because you want to be able to avoid the rules of the court and having the potential for problems. Not to mention, a will only becomes effective when you die. If you had a trust, let's say you had a revocable trust, when does that become effective? Immediately. And so if you're disabled, if there's assets in that trust, then you also, you don't have to worry about guardianship, at least as far as those assets that are in the trust. So a lot of times it is preferable to have a trust, particularly, and also if there's reasons for, if you have a business and you want business continuity, well, you don't want to wait for the courts. Or it could be that if you have property out of state, you could have, let's say somebody has property in Louisiana and in Texas. Well, I don't want to probate in Texas and in Louisiana, because then I'd have to pay legal fees in two different states, and there'd be a lot of time delay. So a trust is often better, even in smaller states. If you just had, unless you got rid of that property in Louisiana or Oklahoma or whatever it may be, you may want to get rid of, it may be better to have a trust. All right, so let me see. I see Gary has some other questions here. The next question you asked was, is a living will the same thing as a medical power of attorney? Well, some people do combine living wills and medical powers of attorney, but the answer to the question is no. So let me kind of give you the answer. A living will is, I hate, for lack of better words, is a pull the plug instrument. In other words, if my condition is terminal, if I'm going to die within 6 months, according to my doctor, even with medical assistance, don't use any heroic measures. Let me die as gently as possible. The Barbara Bush, John McCain, die with dignity. If my condition is irreversible, if I'm in a coma and I can't not expect to live without life-sustaining treatment, let me die as gently as possible. And you could have extra things in there. For example, we give options: no artificial hydration and no food and water, blood transfusions, antibiotics, dialysis, CPR. So those are some things. Whereas a medical power of attorney is, I might not be life-threatening. Who can make, if I'm in a coma, but let's say I'm expected to be okay, who can make the decision? Should I have surgery? Should I not have the surgeries? Now, a lot of times we put those extra stuff into the medical power of attorney, like, in other words, do not resuscitate or some of those other things. So you could combine the things under Texas law. I see Gary also asked the question, do the benefits of a trust depend on the size of the estate? No, not necessarily. A lot of times we have trust for even very small estates. So if you had, let's say, that property in Louisiana that you wanted to keep because you wanted to keep, it was a family farm, or there was, for whatever reason, and you just didn't want to probate in both Texas and Louisiana, then that would certainly be a reason for a trust, even though if the estate wasn't large. So if you planned on keeping something, or if you wanted just to quicken the process, because you didn't have to worry about what a judge may or may not do. Sometimes it's a matter of politics, because the state, different judges have different rules, and we don't know who's going to be elected. So quite frankly, unfortunately, and I shouldn't say it this way, but some attorneys forum shop because they say, well, in Collin County, the judge will let us do different things that maybe some of the judges in Dallas County won't. And so they said, life's too short. I just want to get the property to my clients what they want. And so I'm just going to try to go to some place will do what's best for the clients. So in any event, trust can be, trust doesn't matter. There's all sorts of different types of trust. It could be trust within a will. You could have trusts that are created, and have trust within trust. I have an article that's coming that was in my recent newsletter that talks about 9 different ways to use trust in your estate planning. If you're ever interested in our newsletters, it's on our website, dallaselderlawyer.com. And that's the same spot that I told you that if you ever wanted to go to a workshop or listen to podcast, we also have that on that dallaselderlawyer.com. So if you wanted to ever go to a workshop and listen to us, although, the people who go to the workshop get a free vision meeting. And so we promised also those who did this first one-time Facebook Live event, we also promised a one-on-one meeting without charge if of interest. Okay, so let me keep on going. I see that, let me look at, I see another question here that, does the trust provide financial advantages during probate? And then I'll get to your question, Elizabeth. Yes, the financial advantage is you don't have to pay the attorney to go to court. With the trust, it's already done. You pre-plan death. So you put all the assets in the trust. So the whole idea of probate is to transfer title to assets. And so if the assets are all in the box, the trust, then you've avoided probate. So the advantage is that you don't have to pay the attorney or worry about what the courts may or may not do because it's already taken care of. The disadvantage of it is that you have to put the assets in the box, and that's the biggest mistake that people make. So we have to, and it costs more to set up a trust because you pre-plan. You have to, so if you have real estate, you have to do a deed into the trust. Whereas on a will, you don't do anything until after you die, and then you do a deed from the estate after you die from the estate to whomever the beneficiaries are. Now I'm looking at Elizabeth's question. I'm concerned about my 84-year-old mother who's being financially exploited by my mentally ill brother. About 15 years ago, he convinced her to start a business with him, even though she did not need the money because she lives comfortably on my father's pension. Father died in 87. Brothers charge large amounts of money on mom's credit card bill. Oh my goodness, to keep the business afloat. But it could be much more since she admits that she does not know how much credit card debt she has. I'm the executor of the will, but mom, the executor is only when, by the way, I'm going to make this comment as I read, an executor of the will, when does that take place? After mom dies. So far, what I've read is that mom's alive. So the executor, you haven't been appointed as executor until after mom dies and the court says you're executor. So even if you have a will that says you're an executor, that doesn't mean you could act now. It'd have to wait until after mom dies. Now, there might be a power of attorney or maybe guardianship. That would be authority now. But let me keep on reading on your question. She tells me that my brother handles all of her bills and will pay me back if there's any business death at the time of her death. The next thing that, as I stop before I end the question, well, what if mom dies too soon? What if, is there any kind of legal documents? Is there a loan? Is there a note? Has she said anything in her will that says that my brother's share is reduced by the amount that he's borrowed, and he's borrowed X amount and counting? And can you have if he doesn't provide the proof, he at least owes X amount, or so much is advanced? Does she have anything in her will or trust that says that? So she might want to revise what she's done and maybe have a note from brother, I owe mom X amount, or so much is advanced, and I'm going to secure it by whatever. And if it's not, then that's reduced from his share of the estate. All right, well, let me keep on reading. So she tells me that brother handles all her bills, will pay her back, promise, but promises don't mean, you want something in writing. I would like to know the legal ramifications of all this debt. Well, you could try to sue, I suppose, but remember, you don't have any, when you sue on something oral, it may be very difficult to prove. Brother might say, well, that was a gift. Mom always intended to give that to me. How do you have anything to prove to the contrary? Well, anyway, however, even though she does not seem to make this, she has not been diagnosed with any sort of dementia. Now, I would appreciate any suggestions you have on this matter. Well, if just because you haven't, okay, yes, under law, you're presumed to have capacity until a court order determines that you need a guardian. Now, if you think that there are questions on that, it does get on to, I'm going to say that I'm not going to say your brother is abusing your mom and that this is elder abuse. However, the biggest form of elder abuse is often by children, those who you're closest to. And, in Dallas, we're very fortunate because the senior source has connected all the different players, I guess you'd say. The court system, the probate courts dealing with guardianship, adult protective services, the DA's office. Now, I'm not saying that brother has abused mom, but I do say this. Like I said earlier, I think there should be something in writing. Brother has a note secured, hopefully, by some adequate collateral, that if he doesn't pay, that it's whatever it is that mom could foreclose. Now, mom probably would never foreclose on brother. She's been lending him money all along. But at least if there's a note and a debt, and if she dies, it's part of her estate, what's owed to the estate. Now, you as the executor, well, you're not going to probably feel so much for brother as mom does, because he's been using mom for his advantage. He's been taking advantage of mom, and I know that mom loves him, and that's nice and good and dandy. But the reality is it's not fair. Mom hadn't died. He's not entitled to his inheritance until she dies. And so therefore, it would be a good idea to document by proof, having some sort of security that mom has that is owed to her. And it wouldn't be a bad idea if in her will or trust that she have something that reflects that there's this indebtedness that should be taken care of before, and if not, then it's his size of the estate is reduced. I also wonder if there might be something else that we should do. In other words, let's say, Gary's question was asking about advantages of wills and trust. I remember one time we had somebody who just couldn't say no to her relatives. So we needed somebody who could. So what do? We had that person set up an irrevocable trust that didn't have any adverse tax consequences. And we made the trustee somebody who could say no to brother in this case, the trustee. So another option could be that mom sets up a trust where she doesn't have to be the bad guy. Well, you just have to listen to so-and-so, your sister, to be the trustee. Will brother be so willing to ask you for money that he asked for mom? Okay, so there's all sorts of different things that you could do if mom's willing to do them. Is mom willing to protect her asset to be fair? I hope so. By the way, if mom doesn't have capacity, if you're saying, I'm not sure by your question, is if mom really does have capacity or not. If not, then we might look at who is named as the power of attorney. The courts look, or there's another document called Declaration of Guardian and the Ventilator in Comps or Need. The courts might look who's the next of kin. Well, both you and brother might be next of kin. But then they'll also look at who was named as her power of attorney, her agent, rather, under her power of attorney. And so you say, well, gee, who was named as the agent? Well, the courts would look at that and they would assume that whoever was named as agent, it was the one that they would probably want to be in charge of the assets. There is another little document called a declaration of guardian in the ventilator and compensator needs. So if mom's okay, she might want to say, if I ever need a guardian, I want Elizabeth to be my agent. And if Elizabeth can't serve, then I want so and so. And if she doesn't want son, she can even say, I don't want son as my guardian to take care of me or my assets. So you could have that. And so she does have capacity. This might be something that you want to be doing now, as well as the power of attorney, as well as the medical power of attorney that Gary mentioned in the previously here, as well as a living will that Gary mentioned, as well as a Hipaa. You might want to have either you and brother have access to medical records. I usually call it a universal Hipaa, where it says, all of us can have access, the family can have access to medical records even after mom passes. Because usually the hospitals will talk to family members unless there's a screw up. And if there's a screw up, there's these privacy laws. We can't talk to you. So we do a universal Hipaa, which basically says I allow, even if I'm out of it or if I'm dead, I allow family members or whoever mom trusts to have access to my medical records because of the privacy laws. So those are kind of the standard documents that most people have, or some of the things that we've already been asked today by you and Gary. That is either a will or a trust, depending on the facts. So there's not a right or wrong answer of whether you should have a will or trust, Gary. It really just depends on the situation. And we have to usually see what the facts are and say, oh yeah, maybe it's not best to have a trust, or maybe it's best to have a will, or maybe it's best to have a trust. I don't know. And usually what we do is we say, well, here's the pros, here's the cons, what works best for you? Not a right or wrong answer. So either people have a will or a trust, or they have a medical power of attorney, and they have a medical power of attorney, a living will, a Hipaa. Some people have out-of-hospital DNRs. In other words, if you're at home and you don't want to be resuscitated, so the parent, you have something on the refrigerator, assuming the house doesn't burn down, that says, do not resuscitate me at home. I see Gary has another question. I look for the 12 ways. Yeah, it did not say in the January. It's going to be, the article about trust is going to be on the February 2019 newsletter. And so if that has not been posted, it will be posted in the near future. So look for that at that time. And you'll see the different things that we said in general ways, that what things to think about. So there's lots of different types of trust. I always say, how many types of trust? Well, there's as many trusts as there are stars in the sky, it seems like, or how many different types of cars. And you don't have to have just a trust during lifetime. You could have trusts that come into play after death. In other words, if you have a will, you could have a testamentary trust. What does that mean? A trust that says how things go after I die. Why would you have that? So I'm going to explain a few of those things that you're asking about, Gary. One is, let's say you had a minor. Or even if somebody, let's say, was 23 years old. Well, 23 years old, they may or may not be okay to spend money, but it could be that they might spend the money on a red sports car. And a lot of times we say, well, I don't really feel comfortable until somebody is a certain age before they get whatever it is. And that usually that money can be used before they're at that age for their health, education, usually maintenance or support. So for example, I want my child or grandchild to get, if my son dies first, I would want things to go in a trust for their education, and so either if my son's dead and if he's married, his spouse, or maybe another member of the family would be the trustee to use those funds for education for that child or grandchild until they're a certain age. They mature, we think they'll probably mature at age 25, 30, or maybe I'd say a third at 25, a third at 30, a third at 35. And then you could also have an incentive trust. So an incentive in that trust, you could say, oh, I just because that child might party at school, and so I don't want to be paying for a college education if they're all going to a private school. Oh my goodness, how expensive is that? And they're out partying all the time, and that's costing $60,000 a year. To give the trustee discretion to say, well, if you don't have a certain GPA, so you could have incentives on education or finances. You get more money if you get more degrees, or if you have a certain GPA, or if you have, if invested wisely, or if you've gotten whatever it is that's important to the, you can punish people. We had one time we said, if you have if I want to make sure that nobody has, any of my beneficiaries have a tattoo. If they have a tattoo, they're cut out. So the trustee, that was their obligation. With my own daughter, I joked and I said when she came back from her freshman year, spring break for her freshman year of college, I said, I got good news and bad news. If mommy and I die in a common accident, your college education is taken care of. She said, okay, well, you and mommy died. I understand that's good news because my college education. I said, you mean it's good news that mommy and I died? I said, no, if it's not just, she said, what's the catch? I know you. And I said, well, there is this one little minor condition. All you have to do to get those funds for your college education is simply to maintain a 3.8 GPA for 3 semesters. All right, well, so you could have any incentive that you want. So the bottom line is you could have incentives. There's incentive trust. There are also trust. Let's say you have somebody's disabled. We don't even know who's going to, we don't know if our beneficiaries are going to be disabled at the time of our death. And so how can they handle funds? We don't know who our beneficiaries are. There's the old 2-finger test. 2-finger test is if you could feel your pulse, you haven't died, so you don't even know who your heirs are. So the idea is you say, well, I don't even know what condition they're going to be in. A lot of times people think about what's going to happen. They only think about, I don't need a will, I don't need a trust, I could just have a beneficiary designation. That avoids probate. That's true, but doesn't consider the condition of your beneficiary. How do you know your beneficiary is not going to be a minor? How do you know your beneficiary is not going to be disabled? How do you know your beneficiary doesn't have creditor issues? How do you know that they might not have marital issues? Estate planning is really about protection of your family. It's just a matter of what you want to protect. It's just kind of like insurance. What do you want to protect? And it's just, and everybody's different. So that's why every will and every trust is different, because the idea is it's kind of like going through Luby's cafeteria. Do you want a Luann special? I don't know, a Luann platter, or do you want chicken fried steak with gravy? Doesn't really matter. It's what you choose. So the next thing is that you could, some of the other things that you could be protected against that we talked about, creditors. So how does that happen? So you could have in a will or trust, if it goes into an irrevocable trust, even if there might be elements of control of that beneficiary, you could do things in a way you could protect somebody from creditors. I had one time I was having a workshop and the person said, I don't need a will or trust. I could just have a beneficiary designation. So I said, let me ask you just a couple questions. And I found out that one daughter had all this debt and the other daughter was on supplemental security income, Medicaid. Well, Medicaid's means tested. So if it went directly to the person that was on Medicaid, they lose their public benefits until the assets were spent down or other things were done to get eligibility for Medicaid. And the other one, well, all the assets would have gone to the creditors. So it's not just the passing of property upon your death, it's protection of your family. If I had it done in a different way, if it goes into a disability trust, I don't lose public benefits. It's called a supplemental needs trust, to supplement rather than supplant Medicaid benefits. And that way, and also even if you're just disabled, how are you going to handle things? Do you have to go to court, seek guardianship? Well, here we'd have a trustee, it's already done. So you have less legal fees. In the contingency, remember, whether you have somebody that's disabled now or not, doesn't really matter. It's just to give the ability to protect that person in the event that that was the case at the time of passing. Also, the creditor issue, we say, okay, if it goes into a trust, if that person's ever sued. So if you were driving down the street and you ran into a school bus full of children, do you have adequate insurance? Are you protected? Maybe not. And if you're not, but what if those assets are in a trust, whether it be for your spouse or for your children? You give one parting gift where you protected them. All right, so if it's not just that, what else? What happens if your child inherits and they're having marital problems at the time of your death? Well, an inheritance is separate property under Texas law. However, if you were to get divorced, they presume everything is community and you have to prove it. So if things got commingled, you'd have to trace it. What if you had it just go into a trust? Pretty simple to trace. It has a different tax ID number. So it's not you, it's not the child. What happens if it wasn't a marital problem at that time? Son-in-law or daughter-in-law is great, but you have grandchildren and you wanted your share, whatever it is in your state, if your child dies, to go to your children. Well, so your son or daughter gets the inheritance if it goes to them outright, and they may give it to their spouse. I have an I love you will. What's the problem with that? Oh, there's no problem with that, right? Well, what happens? Well, maybe not. It may be that your son or daughter gives everything to their spouse and their spouse remarries. It may go, the assets may go to some family that you don't even know exists. You may have rather it gone to your grandchildren. So the trust could be used to accomplish that as well. And so that's another way, that one of the other things that were mentioned in the newsletter article that Gary, that you're referring to. And other things, sometimes you want to do things for tax reasons. So there's sometimes people have charitable trust. Sometimes people just want to, it depends on, with the trust, I was doing not a workshop yesterday, but I had a speaking engagement yesterday. And I said, who do you want to tax? When you do a trust, who do you want to tax? The one who sets up the trust itself, the beneficiaries of the trust. So you have to see what the goals are. And then the tax issues say, well, if we do it this way, if the one who sets up the trust, it's at that person's tax rate. If it's the trust, it's at the trust tax rate. If we want to tax the beneficiaries, well, it's at the beneficiaries tax rate. And so you use different things. There's certain things under law that you could use to see when you're doing your documents to plan, who do you want to try? Who has the lowest tax rate? Do I want to step up in basis? So let's say I have property, real estate that's gone up in value. I know that no properties in the Dallas-Fort Worth have gone up in value, right? But let's say that did occur, and we wanted to save some of the assets. We want to have a step up in basis. Well, so that would be a way that you say, okay, I want the person who sets up the trust to be taxed. Okay, I know that there's been some other questions. Oh, I see Elizabeth has another question before I get into some of the other ones. Adding on the previous, if my mother won't agree to put anything in writing about having my brother pay off this credit card debt he has charged in her name because she believes him to be very honest, is there anything else I could do at this point? Well, I'm going to have to have, if she's not willing to put anything in writing, I suppose that if you're the executor of the estate, you could try to say it was an advancement. So there's a law in the estates code talking about advancements. And so that you as executor could try to say that was the case. Of course, I would prefer to get things done up front in writing, so I don't have to worry about whether that would work or not work. But yes, there is, where they say there's a will, Well, my wife wants to be named in it, but my will, there's a will, there's a way, and there is ways to try to deal with that. So you could deal with the what it's called advancements in your when you probate the will. But I'd rather have mom have something in writing. Now I do have some other questions that were asked before this event that I do probably need to answer for some people who sent their questions in beforehand. One was the probate after 4 years. Probate after. So this is the question of Tom. Tom, I recognize your name. You were at one of the workshops recently. Can you probate a will after 4 years? So for those who don't know, if you typically you're supposed to probate a will. What's the idea of probate? To transfer property after death. If you have stock and it doesn't have any beneficiary designation, the people, whoever the broker is or whatever it is that's the company holding the stock, needs what's usually called letters testamentary or letters of administration if there's no will, generally, to transfer the title of that stock. However, what happens, or maybe a real estate, what happens after 4 years? You have 4 years to probate a will. Can you probate a will after 4 years? The answer is you can, but you have to show that there was some mistake. Oh, mom had Alzheimer's. The will was held by her. She didn't realize, and she didn't have capacity. Mom just died, and now we just found the will, and we need to transfer the title. What happens then? Let me give you an example of an actual case that we had where in this case, there was a home and there was children from a different marriage. Oh, under Texas law, under intestacy, if you have children from a different marriage, the house is split between the children of the person who died and the surviving spouse. Well, so under the husband's will, it said everything to mom, his wife rather, and then equally to the kids. On the wife's will, it said the home, which was the most valuable asset, all goes to this one child, who's the one that happened to contact us. So what do we do? And it had been 7 years since dad died, and now mom just died. Well, what we did was we first got what you say, well, there was a problem with the will that mom did lack that capacity in this case. And we notified all the beneficiaries and nobody objected. So we probated both mom and dad's will the same day, the same time. Dad's, all the assets went to mom, and then we probated mom's will, and all the assets went to the one child. So we were able to accomplish the goal by probating will, even though it had been 7 years since dad had passed. If we had not done that, when they sold the real estate, it would have to be divided up according to the laws of intestacy as to dad's 1/2. So that's how. So you can probate a will, but only as a muniment of title. That means that there are no debts owed, and it doesn't give letters testamentary. It just says whatever the will says is the way it goes. So there's no executor appointed when you probate as a muniment of title. Elizabeth wouldn't want that because she would want to be the executor because she wants to be in control. She wants to be able to make sure the estate is made whole. There's when you do an inventory, it says what are debts owed to the estate, claims due to the estate. So that should have been one of the things that, what was owed by brother would have been one of the things that Elizabeth would put on her inventory, a claim, or could be one of the things, a claim due or owing to the estate. So that's another thing that could occur when you probate a will. But yes, you can probate a will after 4 years, but only as a muniment of title. That's unique to Texas, by the way, as far as that term. If you said muniment of title in Illinois or someplace else, they probably look at you like you're crazy. So generally when you deal with these brokerage homes or houses or whatever, you have to show them the law of the state of Texas. If it was on real estate, as it was in this case, you have to, um, you should, what we do is we get a certified copy of the order and put that in the deed records of the county where the property is located. This is which reminds me of the thing that I was talking about earlier about that forum shopping, which is a problem for title companies. I told you earlier that some people some attorneys in Dallas County are forum shopping to Collin County just because they don't want to have to go through the difficulties that sometimes Dallas County presents. So if they didn't put a certified copy, and let's say they had real estate in Johnson County, and then they probated in Collin County. Well, they could have possibly probated in Collin County, even though venue probably was not proper. So you'd have to get all the beneficiaries to waive venue. But if they didn't file that certified copy of the order in the deed records of Johnson County, how is a title company going to pick it up? How are they going to know that that property was transferred by the will? Well, they might not. And so in any event, that's something to be considered. Now I see Andy's question. You missed the beginning 3 minutes and you were talking about labor deeds. Would you favor this over a transfer of debt deed for Medicaid planning? Would the preferable be transferring the property to an irrevocable trust? And let me answer those questions. Thank you, Andy, for that question. There are some it depends on the situation. You could use a transfer on debt deed or a ladybird deed for Medicaid. Either one works. A lot of times we prefer a ladybird deed just because of the going back on good title, going through the history of time, whereas a transfer on debt deed only gives title the way the original person got it. And if you had to use a power of attorney to execute to sign the ladybird deed, then that could only be done with a power of attorney cannot be used for transfer on debt deeds. Now, sometimes we do use transfer on debt deeds. So, for example, last week we had somebody, the closest relative was a nephew, and nephew is single, not married, single, unmarried, didn't have children, and we wanted to say how things went after he died, a certain order. With a transfer on debt deed, I could, say, well, it goes to nephew, and if nephew dies, then I go this certain niece or somebody else. Whereas on a ladybird deed, it just goes who the line of descent is under laws of intestacy. So that might be different. So sometimes it's better to have a transfer on debt deed. And sometimes it's better to have a ladybird deed. Generally, most of the times, we do a ladybird deed versus just because the title issues, but not always. So we have to look at the actual factual situation. Now, in answer to your question about the irrevocable trust, it depends upon when we're going to need care for that person. If we thought that the person was going to be okay for a while, then it may be best to use an irrevocable grantor trust, a trust in which the person who signs the trust has control. The reason for putting it into the trust is you design the trust so it has no adverse tax consequences. So if you had the over 65 and homestead exemption, that would continue. If the person died, you get a step up in basis. In other words, you wouldn't have to pay capital gains taxes on the appreciation from when they acquired it to the date of passing. And then let's say that somebody needed Medicaid, that person needed Medicaid within 5 years, we could take it out of the trust and give it back to that person and always do a ladybird deed. So you give the flexibility of it being able to sell the property, and you've got the clock running for Medicaid purposes. So the answer now, because it's more expensive to do a revocable trust, it probably should have some value, or you should have other assets that need to be put in the trust before it's generally recommended. But if it's a more valuable asset, then yeah, for sure. Now, a homestead doesn't count no matter what the value is for Medicaid if you're married. If you're single, the equity limit has to be $585,000 or less in year 2019. Now we do have one situation which is very odd. and not the normal situation. In this case, the wife is going into a nursing home, and the husband inherited this property. It's 15,000 acres in West Texas. But if it's all attached to the home, it doesn't count as a resource. 15,000 acres, homestead. Yeah, and actually under the Medicaid rules, if you're married, there's no limit, but that value is far greater than the 585,000. So what would you do there? Well, since she needs care immediately, you would show that it was still a homestead, it's all attached. But then after we get eligibility for Medicaid for the wife, then we might put that property, because it's something obviously it's passed from generation to generation, that we would put into the trust, an irrevocable trust, because if the husband needed care in the future, the limit was only 585,000. So we get the clock running for him. We wouldn't do this before we applied for Medicaid for her, because then there would be a transfer penalty. The irrevocable trust is subject to a 5-year look-back period. However, like I said, you could undo it. In other words, if you take the property out and give it back, it's like no harm, no foul. So that's another possibility as well. All right, so the next question I have is from Tom. We talked about the affidavit of heirship and the transfer on death deed at the workshop. Would you both at the same time, or do the affidavit of heirship to go through the process first? Okay, so Tom's question was, okay, when do you use an affidavit? First of all, I should explain what an affidavit of heirship is. Generally, when you have no debts, then and we want things to go to, under the laws of intestacy, you often can sign it. The person who was closest relative and two disinterested people could sign an affidavit of heirship to transfer the property to the beneficiaries, the heirs, as a matter of law. So if you're, let's say that somebody is married and they have 2 children, but they didn't have children from prior marriage, that so those children are from the same marriage, then it's going to go to the surviving spouse. So first you would do, to make sure, usually I would do an affidavit of heirship first before I did the transfer on death deed. So now, even though it's clearly the surviving spouse's property, this way it's filed a matter record, so it shows, yeah, now it went to the spouse, and then after it's in the spouse's name, the chain of title would show now the transfer on death deed or the Lady Bird deed. So it's clear that so that a title company will check, when they check the deed records, they can see how things went. But sometimes you don't do an affidavit of heirship. Some title companies won't accept it if it's done within the first year or 2 after the person's death, because they think that there's going to be creditors out there. If there's creditors out there, they don't want to give good title, because they think that if there's going to be creditors out there, they're going to sue in the first year or 2. So they might not accept any affidavit of heirship in the first year or 2. I see one more question from Andy. The irrevocable trust you mentioned starts the 5-year clock, but the elder person would maintain control of the money until death. Do I understand correctly? Well, kind of. They could be the trustee. They would have the ability to change beneficiaries, the right to occupy your home, maybe the right to income, depending on the way you set up the trust. And so under IRS rules, they would be considered to be in control. But because it's an irrevocable trust, it gets the 5-year clock running for Medicaid. So yes, you could design a trust where it doesn't count for Medicaid, subject to the 5-year look back, but it's still considered that person's who sets it up's money as far as IRS purposes. So it's taxed to them at their tax rate, yet it doesn't count as an asset for Medicaid. So yeah, you could see that you could use trust in many different ways. This is just one of those different ways. And it does give immediate credit protection when you have an irrevocable trust, except for existing creditors. If you had somebody already owed, then that could be, you still owe that. You can't defraud a creditor. I see I'm running a little bit low on time. I don't know if I have a chance to see if there's something that I haven't answered. There was just one other question I see or there is one more question I see from somebody else, from Jane. She had her husband that's going to need to be in a nursing home, and the question for her was, can she keep all of her income? And what about her 401k? Would it count as an asset or not? There's been some verbal statements now, just on February 7th of 2019, there were some clarifications by the state that said if you're under 70 and a half, if the 401k is invested in the form of an annuity, it will not count as a resource. And if you're over 70 and a half, they will look at it as a non-countable resource for Medicaid if you're in payout status. In other words, you started making distributions. You might be interested, we wrote an article about that in one of our newsletter articles as well, and how we take advantage of that situation. So sometimes we want it to count, and then we want it to not count, and so we might start making the distributions at a later date. So so there's different planning you do. Now, on February 7th, 2019, the clarification from the head attorney from the state, although not in writing yet, is that even though there's a distribution, that would also be considered income in the month of receipt. However, they might divide it by 12 as far as how they determine that income, although that's what they're considering strongly. It's not just that income in the month of receipt, but they're just going to divide it by 12 is what they're leaning toward at this time, Jane. So the asset would not count if in the form of annuity for you, Jane. However, they would look at the income in the month of receipt. I see that there's a few more things. I see a lot of people are thanking us, and I appreciate that. We just have let's see, I guess that's really, I think our time has run out. I appreciate all y'all who participated in this first FaceTime Live event. Again, if you did, as we've done with people who went to workshops, if you contact our office at 214-720-0102 or sign up online, well, you could just contact us at our office, and then we could set up a mutually convenient time, if you would like, to have a free one-on-one vision meeting where we'll look at your own particular situation. I know that some people like you, Elizabeth, were out of town. If you wanted to do things by Skype or FaceTime or some other way, just even a phone call, that's okay too. And I'll be glad to try to talk with you and anybody who wants. Of course, we do have our workshops every 3 weeks. And if you're interested in that, you can not only call that telephone number 214-720-0102 or sign up on Dallas Elder Lawyer, DallasElderLawyer.com. I thank you again and you can listen to different podcasts of our radio show, which is 3 times a week, that you could also see on our website that has different things on SoundCloud for various radio shows that we've had on whatever people ask about as well. I thank you all for your time and attention. I hope this has been helpful for you. Thank you.